Добрий ранок, дорогі пані та панове. Good morning or good afternoon, dear ladies and gentlemen. Thank you for joining us today on Friday during the second session of our two-part transitional justice roundtable. And first, I would like to thank also our amazing speakers who have been generously flexible in arranging this roundtable and changing the time. And we are very happy that although we are meeting on a virtual basis, we thus have been able to welcome more people from different parts of the world, and we hope that it will contribute to the qualitative discussion today. A little bit of the rules. Well, first, I'm sorry, I forgot to introduce myself. My name is Katarina Busal. I'm a Robert Bosch Stiftung Fellow with the Russian Eurasia program at Chatham House. And today we're going to speak about Amnesties, truth-telling, and the preferences of the civil society in conflict and post-conflict reconciliation. We will draw from the examples of different conflict-affected countries, but we'll also have obviously Ukraine as a focus. And our speakers, our brilliant three speakers, will be presenting for 10 to 12 minutes each. And then we will have a Q&A session. To ask a question, there are two options. So you can raise your virtual hand and you'll be given the floor. And I would kindly ask you to introduce yourself, to explain your affiliation, and then obviously to ask a question. Or you could write a question directly into the chat function, and we will read it out, and a respective speaker will answer a question. Please let me remind you that the event is on the record, and we will be releasing the video of this discussion sometime soon. So you will be able to rewatch it, and the colleagues who haven't been able to join will be able to see the recording of the discussion as well. As I said, today we focus on truth-telling and amnesties as part of the reconciliation process during and post-conflict. And in the context of Ukraine, obviously there is a conundrum with this question that was generated by the Minsk agreements, which, as interpreted by Russia, provide the blanket amnesties for the perpetrators on all sides of the conflict, whereas Ukraine and Ukraine's partners disagree on that and say that no amnesties for the gravest crimes may be possible under the Minsk agreements. And recently, we have had an unlikely testing ground for an amnesty question around the world, but especially in Ukraine. Coronavirus, COVID-19, prompted many governments to grant the early release and amnesties to reduce the threat of the spread of the virus in the detention centers and prisons. But in Ukraine, we have seen the big social and political resistance to such early release and amnesties initiative. Whether that could be a worrying indicator as regards the openness of the society to amnesties regarding the armed conflict is something to be investigated and analyzed. And before I give the floor to our brilliant speakers, I would want to say that even without saying a word, this panel is already given a very strong statement as regards the policy making and especially peace and reconciliation policy making in Ukraine. Rarely does Ukraine, as of now, still have gender parity on the decision-making level, especially on the issues of security, justice, and reconciliation. And today we have not just gender parity, but we have a female majority, and this is a very promising sign. With no discrimination to our amazing first speaker, Dr. Myles Jackson, of course. Dr. Jackson is an associate professor of law from the University of Oxford. He specializes in general international law, has written extensively on the issues of jurisdiction, immunity, the law of state responsibility, and the various aspects of international and domestic criminal law. Myles serves as a faculty committee member of Oxford Pro Bono Publico and the steering committee of the Oxford Institute of Ethics, Law and Armed Conflict. He teaches international law and armed conflict and criminal justice, security, human rights, constitutional law, and administrative law. He was previously the convener of the Oxford Transitional Justice Research Group, and he also practiced and clerked at the Constitutional Court of South Africa and the International Court of Justice. So, dear Myles, the floor is yours. We're really waiting to hear about your experience. Thank you.
Thank you very much to Katerina and to Anna and to Chatham House for the invitation. And to each of the speakers yesterday, I learned a lot about both Colombia and Ukraine. I've been asked to speak today about amnesties for grave human rights abuses and international crimes. To start with two qualifications. First, I will be speaking predominantly from a legal perspective, at least until the last part of my talk. I mention this as a caveat because it has long been said, often rightly, that lawyers unduly dominate the policy-making space in transitional justice. We unduly dominate it because the law seems to offer a tempting moral clarity and simplicity in complex situations. Second, I emphasize at the start the narrowness of what I will say. I'm speaking only about amnesties for grave abuses. This is just one part of a wider question about accountability for wrongdoing in conflict. And accountability is itself just one part of a much wider set of questions around transition, something captured very well in the framework we talked about yesterday. With those two qualifications in mind, let me turn to substance. I will proceed in three parts. First, I will discuss Ukraine's international obligations in relation to gross human rights abuses committed during the conflict and the question of amnesties. Second, I will discuss briefly the issue of the ICC. And third, I will conclude by flagging some of the tensions that might arise within different planks of the transitional justice roadmap and between specific planks of that roadmap and wider goals. That's to begin. Ukraine's international obligations and the policy space these obligations leave. I will start with the conclusion. My view is that it would be lawful for Ukraine to choose to approach the grave abuses committed during conflict in a range of ways. Crucially, these ways include deciding to run an alternative justice process. Alternative here meaning alternative to criminal trials. I understand the term alternative justice process is itself broad. There is a range of approaches that have been utilized by different states, but to give two examples, South Africa's model, used in the mid-1990s, entailed a straightforward offer of amnesty in exchange for disclosure, full disclosure, amnesty from civil and criminal penalty. Colombia's model, as Kirsty explained yesterday, is more complicated, but crucial for present purposes is that under the special jurisdiction, the disclosure of truth and acceptance of responsibility entails at most the imposition of certain sanctions of a reparative and restorative nature. Each of these models was lawful under international law at the time it was adopted. By international law here, I mean international law binding on the specific states. In my view, the same would be true for Ukraine. International law does not require, in all circumstances, criminal trials. And this conclusion holds for the gravest abuses and those most responsible for them. Why is this the better view of the law? As a starting point, there's a crucial conceptual distinction that is sometimes overlooked in legal scholarship and indeed in judicial decisions. By definition, we are dealing with the gravest wrongs. We are dealing with fundamental breaches of international law, torture, war crimes, crimes against humanity. There is no doubt that each of these is peremptory. Each of these is a jus cogens norm. That is to say that no circumstances whatsoever justify the commission of international crimes. This then is sometimes taken to generate an additional conclusion that each of the cluster of duties that is connected to that grave wrong is itself peremptory, including the duties to investigate and prosecute wrongdoers. But that is a conceptual mistake. That assumption is false. While it is true that the duty not to torture is absolute in international law, is peremptory, is jus cogens, it does not simply follow that any duty connected to it, and in particular the prosecutorial duty, itself carries that status. Thus, moving from that conceptual point to positive law binding Ukraine at this point, it is often said that customary international law imposes a duty on states to prosecute certain wrongs. That is certainly true, but with a qualification. There is no good reason to think that duty is peremptory or absolute. That is to say that it is non-limitable in exceptional circumstances. Indeed, as Louise, who will speak next, has shown in detail, certain kinds of amnesties continue to be used and accepted in state practice. Second, as to treaty law, certain widely ratified treaties, including ratification by Ukraine, the ICCPR and the Convention Against Torture, do impose duties to prosecute. But again, there is no reason to think that those duties are absolute. There's no reason to think they are applicable in all circumstances. They are to be interpreted, as with all treaties, in the light of general international law's acceptance, continued acceptance of the permissibility of amnesties in exceptional circumstances. And finally, this is likely true too of the procedural obligations that are generated by substantive rights under the European Convention on Human Rights. As always, I should say, as a lawyer's disclaimer, there are other interpretations out there, and with respect to the European Court of Human Rights, there is a risk that the court might take a different view of amnesties. But in my view, this is not the better reading of existing case law. That then is my first point. International law is relatively unprescriptive when it comes to prosecution specifically. The consequence is that the policy-making space for the state is broad. My second point concerns the ICC, and I've pulled the ICC out of the first discussion for a particular reason. It's really in a different category. Although we are dealing with an international actor, we are not really dealing with Ukraine's international obligations owed by Ukraine under the statute. We're not really dealing with that. To be more specific, it is true that since the 212.3 declarations under the statute, the situation in Ukraine has been under preliminary examination. The ICC and its institutions, particularly the OTP, the Office of the Prosecutor, are required to apply the statute. And as I understand the current position, the situation in Ukraine is still under preliminary examination. But the OTP's 2019 report says that it will seek to finalize its assessment of admissibility this year. The question then is not really about obligations owed by Ukraine to other state parties, but rather how any potential alternative justice process fits with an ICC investigation, particularly as a matter of complementarity. This is hard to say. For one, the ICC prosecutor has a statutory discretion to not proceed with an investigation or prosecution if it would not serve the interests of justice. But up to now, the prosecutor has indicated that she reads this discretion extremely narrowly, refusing to take into account wider interests, including interests at stake in transition. However, here again, the Colombian case is potentially illustrative, with an extensive, long-standing preliminary examination, during which the Office of the Prosecutor signaled a willingness to accept, for purposes of admissibility, much lower sentences than would otherwise be applicable given the nature of the crimes. This would be then relevant to any assessment of complementarity undertaken by the prosecutor or the court under the Rome Statute. Third and finally, I want to touch on certain tensions that might arise within the transitional justice framework. At the outset, I need to emphasize, for the avoidance of all doubt, that the claim I made above, that international law is not prescriptive on the matter of criminal trials, means exactly that. It is not prescriptive. It only means that trials are not required. It is certainly permissible under international law for states to choose to undertake criminal trials and punishment. Indeed, it is entirely permissible for states to choose to prioritize criminal trials on the basis that, for instance, justice itself demands it, on the basis that anticipated instrumental gains in relation to the rule of law justify the pursuit of trials, or even for a combination of ordinary political motives. And to leave the law, it is not for me, knowing little about the complexities of Ukraine and nothing about the wishes of victims, to say that an approach that prioritizes trials is unwise or unjust. But I conclude with one point of caution. Experience in other jurisdictions suggests that in transitions and peacemaking, trade-offs are endemic. They are inescapable. Barring the case of an opposing party entirely vanquished militarily, where the state can impose its will, the political realities of these situations mean that decision makers will likely have to face trade-offs between ambitions of truth, memory, institutional reform, peace, economic reconstruction, and justice. Some of these trade-offs will be bitter, but experience tells us that amnesties, or more widely, alternative forms of prosecution and sanction, can play an important role in securing other ends. Thus, to conclude and connect the parts, the policy space left open by international law is wide, and within that space, decision makers are likely to have to face significant tensions and trade-offs. Thank you.
We will move on with the issues of amnesties, and I would like to introduce the second speaker, Professor Louise Malinder. And I would just want to mention that during the registration, many colleagues from Britain, from Ukraine, from Germany wrote us, how have you managed to get two best international experts on amnesties? So I just wanted to thank again Louise and Myles for making it, for being so flexible and generous. Professor Malinder's research interests are international human rights law, international criminal law, law and politics in political transitions. She is a known expert on the issues of transitional justice in Northern Ireland and has contributed to a vast number of research projects in different transitional contexts, namely Cambodia, Chile, South Africa, Israel, Palestine, Argentina, Uruguay, and many, many others. Professor Malinder has been awarded the British Society of Criminology Book Prize, jointly awarded, and the Hart Socio-Legal Studies Association Early Career Prize. She's also a member of the Institute of Integrated Transitions, Law and Peace Practice Group, the Royal Irish Academy's Ethical, Political, Legal and Philosophical Committee. She's also a chair of the Committee of the Administration of Justice, a human rights non-governmental organization based in Belfast, Northern Ireland. Professor Malinder is a professor of law from Queen's University, Belfast. Thank you very much for joining us, and the floor is yours.
Many thanks, Katerina, for that introduction, and also thank you to you and Anna and Chatham House for organising an event that is shaped up to be quite fascinating, both today and already with Myles's opening remarks. My presentation, I think, follows quite nicely from what Myles has said, because I'm also going to focus on amnesties. And as we've heard, debates over amnesties are a difficult but often inevitable component of efforts to end armed conflict. I think it's important to start off conversations with amnesties by just stating what they are, because this term is often used in a variety of settings to mean different things. But at its core, amnesties are extraordinary legal measures that are intended at a minimum to remove criminal liability for specific categories of crimes or offenders. So they are granted only to those who are at risk of criminal investigation and prosecution, and are designed to prevent those prosecutions taking place. Through removing criminal liabilities, amnesties are often viewed as impunity that enables wrongdoers to evade responsibility for their actions. However, closer examination of how amnesties are used during or after conflict suggests that their relationship between amnesties and holding wrongdoers responsible for their actions is often more complex and mutually supportive. So in this presentation today, I want to try and tease out this relationship with respect primarily to how amnesties are granted for combatants. Towards the end of the presentation, I'll focus a little bit on amnesties for functionaries of occupied territories. But before I get into these questions, I just want to give some brief context on the use of amnesties during and after conflict. So as Myles mentioned, amnesties are very common in these settings. Roughly half of all comprehensive peace agreements adopted since 1990 have provided for some form of amnesty. Amnesties are also widely used during ongoing conflicts. In most instances where an amnesty is granted, it's not understood to be an end in and of itself. Instead, amnesties are mostly used to achieve other objectives. So to think about what these might be, where amnesties are granted to combatants during ongoing conflict, their objective could be to encourage rebel fighters to surrender and disarm, and possibly to provide intelligence that could be used to fight the insurgency. Thus, such amnesties are intended to weaken non-state armed groups and to reduce the intensity of the violence. Once a peace process is launched, amnesty's purpose can shift to being part of measures to build trust and confidence between negotiating parties and ensuring that all parties are willing to sign up to a peace agreement to end the violence. But peace agreement amnesties can be intended to deliver more than simply an absence of violence. They are sometimes intended to promote social unity and reconciliation through ensuring that any transition is inclusive of all parts of society. Amnesties with respect to situations of occupation are much less common, particularly in recent decades. However, Croatia provides an example where in 1996, persons who during the conflict had been resident in temporarily occupied parts of the country and had engaged in criminal acts and armed rebellion against Croatia were granted amnesty following the conclusion of the war, provided that they had not committed offences that were ineligible for the amnesty. The UN Human Rights Committee Against Torture later stated that this act was adopted to speed up the demilitarization of the temporarily occupied territories and to speed up the return of exiled persons, and to make the peaceful reintegration process of those territories under complete sovereignty easier. So you can see there are a number of positive goals that amnesties can be intended to achieve. Clearly, where amnesties are intended to end armed conflict, they can be tied to the transitional justice goal of preventing a recurrence of violence. And indeed, this objective is often built into the design of amnesty laws through the inclusion of conditions that require combatants to disarm and to refrain from further violence and criminality, with the possibility that individual grants of amnesty will be withheld or removed if an individual breaches these conditions. However, through careful use of limitations and conditions, amnesties can also be designed to complement criminal justice, truth-telling, and lustration components of transitional justice policy. So I'm going to speak about each of those components in turn. So firstly, criminal justice. Well, the point to note here is that most amnesties contain limitations. By this, I mean it's rare for an amnesty to grant immunity for all crimes committed in the past. Instead, amnesties are generally drafted to ensure either that they apply only to a narrowly defined set of crimes or offenders, or that amnesty is granted broadly, but within that there are some specific exclusions for particular crimes or offences. In designing limitations, a state often has to adhere to its obligations under national law or regulations under international law restricting the use of amnesties in certain circumstances, as well as obligations under international law. And here I agree strongly with Myles's analysis of the contemporary international law standards on amnesty being less restrictive than they are often presented. However, limitations often go beyond what is formally required by the law and may include, for example, crimes that are particularly repudiated or problematic within a national context. So, for example, conflict-related amnesties often exclude crimes related to corruption or crimes committed by foreign fighters. The use of limitations should enable amnesties to complement selective prosecution strategies by prioritizing prosecutions of those responsible for crimes that were excluded from an amnesty. However, experience indicates that this is only possible where a criminal justice system has the necessary capacity and resources to prosecute the crimes, and where there's adequate political will to ensure that prosecutions are carried out. Turning now to the relationship of amnesties and truth-telling. Firstly, it is common practice for amnesties to require combatants to make individual written applications for amnesty, in which they have to, at a minimum, disclose some basic information, such as admitting to their affiliation with an illegal combatant organization. Beyond this, a small number of amnesties in ongoing conflicts have been conditioned on surrendering combatants, providing fuller accounts of their own involvement with criminal offences, or disclosing information on the acts of their former comrades. In addition, since 1990, almost 10% of comprehensive peace agreements have required offenders to tell the truth about their actions in exchange for amnesty. In these instances, the offer of amnesty serves to incentivize former combatants' engagement with truth-telling processes. The conditional nature of the amnesty also means that if it subsequently becomes known that these amnesty persons did not truthfully disclose their criminal acts or had withheld information about criminal acts that they had been required to disclose, then the amnesty could be revoked. While amnesty does not guarantee that everyone with information will come forwards, the experience of the South African Truth and Reconciliation Commission highlights how this approach may provide victims and society with greater degrees of information and acknowledgement that may be obtainable through formal justice processes, particularly where those processes are overstretched. Such information can be important, not only for providing answers to victims and helping to locate the remains of disappeared persons, but also for countering efforts to deny and distort responsibility for criminal acts, and for encouraging communities to look beyond their own victimhood and to recognize the harms experienced by others. I'll turn now to the relationship between amnesties and lustration. It's relatively rare for amnesties to be directly conditioned on offenders taking part in lustration processes. However, experiences in Kosovo, Bosnia, and South Sudan demonstrate that amnesties and lustration can be implemented as part of a comprehensive peace agreement or transitional justice policy. Whereas amnesties are only applied to those suspected of criminal offences, lustration processes can have a broader remit. This can mean that they can seek to remove or bar from public office persons involved in administrative or disciplinary wrongdoing, in addition to those involved in criminal offences. Lustration may have punitive effects, but that is not its primary objective. Instead, it seeks to rebuild the legitimacy and capacity of public institutions. However, given that lustrated individuals may face reputational as well as professional and financial consequences, international human rights standards make clear that lustration should only be applied to individuals based on their own responsibility for wrongdoing, and that procedural safeguards should be followed, such as the presumption of innocence, the right to a defense, and the right to appeal. Lustration measures can be used to ensure that combatants who engage in war crimes or other conflict-related crimes cannot serve within public office in the post-conflict period. However, where a combatant group wishes to transition to being a political party, these types of lustration measures may provide a block to a political settlement. Lustration measures also provide a link to the final remarks I want to make on the question of amnesties for government functionaries in temporarily occupied territories. As is well known, Article 54 of Geneva Convention 4 precludes occupying powers from altering the status of public officials or judges in occupied territories. This provision was intended to ensure that the administrative functions of the occupied territories could continue uninterrupted in the interest of the population of those territories. Thus, while international humanitarian law provides that functionaries should be able to resign for reasons of conscience without facing any coercion or discrimination from the occupying power, there is no international law expectation that they should do so. So where during an occupation, government functionaries, particularly at lower levels, continue to carry out their duties without any involvement in criminal behaviour, they should not be included within the scope of an amnesty in the post-conflict period, as, simply put, there are no crimes to be amnestied. However, if there are allegations of criminal behaviour, then determinations of whether they can receive an amnesty should depend on whether their actions fall within the scope of the amnesty and whether they comply with any conditions on which the amnesty is granted. Similarly, adhering to the principle of individual responsibility, lustration should only be applied to government functionaries where there is evidence that they, as individuals, have been involved in criminal or disciplinary wrongdoing. So just to briefly conclude, while it is inevitable that questions of amnesty will arise as states seek to move beyond violent conflict, any consideration of whether or how an amnesty should be introduced should bear in mind the following 4 questions. Firstly, would an amnesty further the goals of a peace process, such as preventing further violence and promoting reconciliation? An amnesty will only be viewed as legitimate by a population if, at a minimum, it has these types of positive objectives. Secondly, which groups of persons should be granted amnesty to achieve these goals? My purpose in asking this question is to emphasize that, rather than applying broadly, the scope of amnesties should be tailored narrowly to only those groups for which granting amnesty will contribute positively to the peace process objectives. Thirdly, would requiring individuals to fulfill conditions in order to obtain or retain an amnesty help to support the peace process objectives? And fourthly, how can limitations and conditions be used to ensure that the amnesty does not undermine the work of other transitional justice processes, and ideally can complement such processes? So thank you very much.
Amazing. Thank you very much, Louise, for touching really the connection of amnesties with the crucial issues of truth-telling and lustration, something which has been widely discussed in Ukraine. And now we will get a very unique human perspective, along with the lawyer, legal perspective on these issues from Ms. Alexandra Matvichuk. Alexandra is the head of the Center for Civil Liberties, one of the leading human rights organizations in Ukraine. And I would say that she's a unique bridge between the policymakers, the politicians, the civil society, and the international partners. Alexandra has been involved in the documentation of different human rights violations, including the alleged international crimes in Crimea and Donbass, and she co-authored a few alternative reports to different UN bodies, Council of Europe, the European Union, OSCE, and the International Criminal Court. She also received the Democracy Defender Award for exclusive contribution to promoting democracy and human rights from the missions of the OSCE in 2016. And next year, in 2017, she became the first female participant of the Ukrainian Emerging Leaders Program at Stanford University. Alexandra cooperates a lot with the families of the political prisoners of Ukraine. She famously launched the campaign Let My People Go, aimed at Russia holding Ukrainian political prisoners. And in all efforts implementing international humanitarian and criminal law domestically in Ukraine, Alexandra first did cooperate, and second, she famously involved, again, the families of the victims of the war crimes perpetrated in Ukraine. So she really provides the human dimension, the human lenses to different policy and legal initiatives related to the Russia-Ukraine armed conflict. Alexandra, we are looking forward to hearing your perspective. Over to you.
Thank you very much, Katerina. It's a great honor to take part in this event. As Katerina told, I'm a human rights defender, and my team, since the beginning of the war, concentrated on monitoring of political persecution in occupied Crimea and documenting the testimonies of victims of illegal practice of kidnapping, torturing, and killing people in the occupied Donbass. I personally gathered more than 100 testimonies and speak with more than 100 people by myself. And I must admit that it's a very dramatic stories which I have heard from them. I spoke with people who were beaten, raped, smashed into wooden boxes, whose fingers were cut, whose eyes were pulled out with spoon, or teeth were crushed with different instruments. So I know for sure from these people that it's very important to them not only to restore their physical and mental health, their future, their vision of future, their broken family chain, but also it's very important to them to restore their faith that justice is possible, even if the justice will be postponed in time. So when we start to look through this prism, what we can do practically in order to decrease the level of violence and to fight with impunity in this ongoing war, we divided all roots of problems into two parts. The first part, which Ukraine as a state has a very small influence or no influence at all. And second part of problems, which Ukraine as a state covered by their competence and strongly responsible for solving. And one of such kind of problem is the quality of national legislation. It's very hard to believe, but on the 7 years of war, our criminal code is not harmonized with international criminal and international humanitarian law. We have no responsibility for crimes against humanity, and war crimes described in the criminal code so badly that for these 7 years we have only 2 court decisions according to war crimes. So national investigative bodies and national court system in Ukraine have no legal instrument to properly qualify and prosecute the international crimes, which unfortunately still going on. So when we understood it several years ago, we created a working group with involving international expert and national expert, and created the amendments to the criminal code. After advocacy campaign, we perceived our government to register our draft of law as a governmental one in parliament. And then we push our parliament to adopt this draft of law in the first hearings. But unfortunately, after the reloading the new parliament, we have to start our work from scratch. And we created another working group and registered another draft of law. The number of it for current moment is 2689. And now provide our advocacy effort to perceive the MPs to vote for this draft of law. So as I told, this draft of law provides this very important function. They harmonize our criminal code with international humanitarian and international criminal law. Why it's so important, and for Ukraine especially in the 7 years of war? Because during these all years, our national investigative bodies qualified most crimes as ordinary criminal crimes. And for some kind of crimes, there is no analogy in ordinary criminal crimes. For example, when we remember the statement of a leader of some paramilitary group in Donbass, Zakharchenko, during the battle on the Donetsk airport, that there will be no mercy for prisoners of the war, there is no analogy in the ordinary crimes. Second reason is that even if we have some analogy, for example, killing people, or kidnapping or some other articles, these ordinary crimes not reflected the real nature of international crimes and not consider some important particularities. For example, when we speak with victims of sexual violence, we understood that the ordinary crime as rape in the criminal code don't reflect that moment, that it's very difficult for victims of sexual violence not to express the disconsent when he or she are faced with people with arms. So a third reason is that this draft of this instrument is highly needed for Ukrainian national state bodies. We couldn't take transfer responsibility only to ICC, because even if ICC opened the investigation this year as we expected, according to the policy, ICC is focused only on big fish, the people who on the top of chain of command and are responsible for organizing these international crimes, which is covered by Rome Statute. And it means that thousands of executors, thousands of perpetrators are still responsibility of national state bodies. And also it's important that according to this fact that ordinary crimes have the strict term statute of limitations. So we have so-called deadlines for investigation, and after, when we reach these deadlines, the investigative bodies has to transfer the case to the court or stop it at all. And international crimes have no such kind of deadlines. And we know from the history from other armed conflict that dozens of years can pass, and then the perpetrators can be faced with justice and with responsibility. And last but not the least, that this practice of political persecution and practice of kidnapping and torturing and killing people is still continuous. According to the official numbers, we have 234 people in captivity on the Donbass, but it's only a top of iceberg. We really don't know the real numbers of people who are illegally detained and torturing for current moment. How this problem connected with amnesty? I can show only two examples. The first examples is so-called cold amnesty, which for current moment ongoing in Ukraine. What do I mean? We have a very good idea, and which was enshrined in the program of Security Service of Ukraine. And this program is called You Are Waited in Home. And this program provides opportunity for combatants, for members of illegally armed groups, if they don't committed war crimes, they can return to Ukraine, and they will be participants of this program, and they will not be faced with real prison sentence. Because we have no clear, no proper qualification and no proper investigation, as Ukrainian society don't know if the people who are participants of these programs are really people who don't committed war crimes. It's still a huge question for a lot of human rights defenders. And second example, it's connected with Minsk negotiation, which is still ongoing. In Minsk provision, there is a very abstract provision that according Amnesty, it's written that the amnesty has to be granted to all persons who are connected with some events which happened in some district in Donetsk and Lugansk oblasts, Donetsk and Lugansk regions. It's very wide formulation, and because it's political negotiation, we don't know if in future Russian Federation push Ukraine to provide amnesty for war perpetrator, and it will be very easy to do if they will not face before that moment with the proper qualification of their action. And why I mentioned that in basement and in captivity we still have a legally detained person, because we strongly believe that when Ukraine adopted this draft of law and harmonized criminal code with international humanitarian and international criminal law, it will provide the frozen effect to the brutality of human rights violation in occupied territories, because for current moment, the executives, the perpetrators, they are sure, totally sure that they will be amnestied or they will be exchanged during the Minsk negotiation if they will be arrested. So this will be a clear signal from Ukraine as a state for people that you couldn't hide for the figure of abstract Putin, because responsibility has individual character, and it can save the life and health for thousands of people who live in occupied territories. And I will conclude my speech with that point that when we speak about amnesty as an essential part of national reconciliation in Ukraine, or different ways how to fight with accountability in Ukraine, we have to understand that we speak not only about Ukraine. Russia started a war 7 years ago, but before it, Russia used the same tool as armed conflict in other countries. And we, as a human rights defender who documented war crimes, when we try to find the perpetrators, we find a very interesting insight that the same people who committed and organized war crimes in Crimea and Donbass, before it, they were and organized the same crimes in Chechnya, in Transnistria, in Abkhazia, and in Ossetia. And I'm sure if we connected our efforts not only with Russian, Georgian, and Moldova human rights defenders, but also with Syrian human rights defenders, we will find the same people in Syria. So for me, it's obvious that if we want to broken the circle of impunity, we have to understand that when we try to find moral and balance for amnesty and accountability, we have to consider that we speak not about current existing conflict, but potential future conflict, which can be potential imposed by Russia. But to conclude, finally, I want with the word of one of victims. It's a woman who were released from basement, and she don't provide her testimonies to state Ukrainian authorities. She went only to me because she has some trust to human rights defender. And when I ask her about her motives, because she don't want to to open the official investigation, she told that she believes there will not be peace without justice. Thank you very much.
Alexandra, thank you very much for your very heartfelt and poignant and painful human lenses of the truth and amnesty discussion, and especially for contextualizing the certain issues of the Russia-Ukraine armed conflict globally, because I agree with you that we're not speaking just about the violations perpetrated in Crimea and in Donbass. And at a number of meetings, I could see how the ambience within the audience changes when first the human rights defenders speak about the alleged war crimes in Crimea, and there is one level of interest, but then the level of interest changes when, for instance, the crime of the forced conscription, the war crime of the forced conscription into the Russian army in Crimea extends to Syria, because those forced conscripts are being used to fight in Syria, and that shows a completely different dimension of what's happening in Ukraine. So thank you very much for bringing that. Thanks to all our speakers. I again invite our guests to either type the questions in the chat function or raise their electronic hands. We already have one question from Mr. Oleg Martynenko, who is one of the known transitional justice experts in Ukraine. And his question is as follows. He says, can a carefully designed amnesty, as described in Freeman's work, be recognized as part of restorative justice, or does an amnesty always remain as part of retributive justice? Who would like to take the question?
I'd be happy to.
Thank you.
Yeah, that's a great question. I think in answering it, a starting point is to think about what do we mean by restorative justice. There is a tendency in transitional justice literature to describe anything that's not trials as restorative justice. But for criminologists and others who work more closely on restorative justice processes, the concept has quite a precise meaning, and it requires a reinterpretation of the nature of wrongdoing and the experiences of victims. So restorative justice, under that lens, is intended to be reintegrative. It's intended to bring society or communities back together in a particular way, rather than exclude individuals. And the experiences of victims are understood as harms, rather than being primarily thought of as crimes. And what is significant there is that where, for example, someone is a victim of sexual violence, in the criminal justice process, we think just of the violation, of the moment where the act was committed. In a restorative justice process, you can think much more inclusively about the myriad ways that that suffering has impacted on a person's life and their family life and their ongoing health conditions. So it gives you a way of thinking more broadly about harms that people experience. Also, restorative justice processes are intended to bring victims and perpetrators together in some way. There's some form of interaction between them where the perpetrator should acknowledge wrongdoing that they've been responsible for. And there's usually an element of community involvement. What that might look like will depend very much on the setting. And an outcome of a restorative justice process usually is not exclusion in the form of imprisonment, but it can involve other forms of sanctions. So community service, apologies, making some sort of material or financial contribution to the victims. And it can also include provision for healthcare or different things. So precisely what the outcome should be tailored to the harms that the victim has experienced. So it's meant to be a much more victim-centered approach in that sense, rather than criminal justice that just focuses on the perpetrator with the outcome of sending the perpetrator to prison and perhaps doesn't look at the victim's needs as closely. So that's my understanding of what restorative justice looks like. And yes, I think restorative amnesties can play a role in a restorative justice process, provided they're carefully designed. And conditions and limitations are one way of doing that. But I think to make it work meaningfully, you have to think through about how that works. What is the form by which an amnesty would be granted? Is the amnesty going to be conditional on the offender taking part in this process and adhering to all the prescribed outcomes of the restorative justice initiative? What happens if a victim does not want to take part in this process? Because all victims are very different and have different needs and experiences, and some, will dedicate their lives to seeking answers and pursuing accountability. For others, healing for them may mean trying to look to the future and trying to put the past behind them. So this process wouldn't be for everybody. And so conditioning an amnesty on a victim wanting to take part in this process would very much constrict how broadly the amnesty could be used. So I think there might need to be careful consideration of, to what extent this is a requirement of an amnesty process, or perhaps an option that could be part of an amnesty process that could have other conditions attached to it. But yes, in answer to the question, it is possible to envisage that.
Maybe I'll just add one thing to Louise's answer, which picks up on the framing of the question, which is about careful design. And it's just to emphasize that the range of different processes, the range of different designs of the amnesty is extremely wide. And sometimes we all have a tendency to think in models. The South African model is a simple swapping. The Colombian model is more sophisticated, but has these elements. But what is valuable and justifiable as determined locally may be very different in Ukraine. And so careful design can open up different ambitions for different people as well. There might be overlapping goals. There may be non-state, state distinctions. So design, I think that the temptation to just impose something from outside is to be resisted.
Thank you very much, Louise and Myles. And I will abuse my position as a chair and ask a question to Alexandra. Alexandra, on the basis of your communication with the victims, and as I understand, on the victims of on different sides, to say so, how would you comment on their openness to having a certain truth-telling initiative? Because we don't have, as we learned from the discussion yesterday, we don't have a comprehensive transitional justice roadmap yet, let alone the specific mechanisms envisaged for the justice and reconciliation process in Ukraine. But there are these rumors that there will be a sort of a peace and truth-telling mechanism. So how are the victims open to contributing to it? And what's your opinion about that? Thank you.
For sure, it will be different point of view of different victims, but I think that I will not be mistaken if I focus your attention to general trends among the victims. The first trend that it's scary to say something during the ongoing conflict when you don't know how the situation change tomorrow or after months. And second, it's very hard to tell something openly when you have such small level of trust to state institution, which we now observe in Ukraine. For example, we working now with a case from the small town on the Ukrainian controlled part of territory. The locals were killed by supposedly security guy from security service of Ukraine. There are a lot of evidence of this fact, but we still are waiting for the court decision. And very important element, when we try to gather evidence and to help families, we understood that they obligatory have to be a witness of the moment of his arrest in this village. And then when we start to check this case, we understood that the victim are, but all of the people are afraid to speak. So I think that for current moment, the main trends will be that victims are not be willing to say openly because on security issue and because the issue of legitimacy of state institution in Ukraine.
Thank you very much, Alexandra. I think it really feeds into what we heard yesterday about the need to well, to ensure the institutional reform and for people to feel secure in coming up. And also, I think it was a very important point from the speakers yesterday that they really work on the communication strategy of the transitional justice roadmap to really explain to the people what the initiatives are and what security guarantees they would have. And well, we will see how successful it's going to be. We actually have another question, a more general question on truth commissions, and I think it would go well with the Myles or Louise if you're willing to reply. The question is from Natasha Kurt. I'm sorry if I mispronounced the surname. The lady asks, sorry if I missed discussion on this and couldn't come yesterday. What is your view on truth commissions? Can you say something about their role in establishing an agreed narrative of the past and their role in establishing historical truth? Given issues like Holodomor, etc., can you say something about this? Well, Holodomor, it's a great famine artificially organized by Stalin to exterminate, including the peasants in Ukraine. But I think generally the question is about truth commissions, and perhaps you could comment on the acceptance of such a truth-telling initiative in different contexts, because there have been many arguments in Ukraine that the Ukrainians are not the people from the African continent. So this kind of discussion and seeing your the person who wronged you is not that culturally ingrained the way it would be in different African states. Who would like to take the question?
Sure. So there's, as the question indicates, there's an immense complexity around what truth means in this context. In brief, I would say that truth commissions can play an individualized role for particular victims in securing information that is relevant to them. I think that is one common ambition of truth commissions, in a narrow individualistic sense of what actually happened with respect to me, or who was responsible for it, or even in certain circumstances, information about the remains of family members. So there's an individualized aspect to some truth commissions. More widely, yes, I think it is fair to say that a formalized process like that can contribute to the establishment of a historical record, much like other processes, including trials, in a particular distinctive way. I say that with a degree of tentativeness because there's two conditions here. One is that there's inevitably a limit to pursuing a historical truth through a particular institutional framework. So in setting the ambition to just establish a historical truth, it would be setting up the institution probably to fail. That's not to say that it won't establish certain matters on record. And then the second part of the question is about an agreed narrative. And I'm probably a little bit more worried about the agreement part of that. So it is certainly the case that in many systems, disagreement that existed about the conflict and how we understand that that was there before a truth commission persists after it. And so you may have to, the ambition of an agreed, we all agreed in situations of conflict is probably too ambitious.
Thank you, Myles. Alexandra, Louise, would you want to add something?
Sure. I mean, to my mind, South African truth commissions are often tasked with understanding the causes and consequences of the violence. I think they're less about delivering answers to individual victims. That can result, particularly for emblematic or high-profile victims' cases, but the vast majority of victims who engage in the process perhaps won't even get to participate in public hearings, and they certainly won't get individualized information back. So the goal is often to produce exactly the sort of historical narrative that the question asks about. And I think I agree with all of Myles' skepticism that you can never produce one accurate historical truth. History is something that gets, reviewed and revised in light of, new evidence coming to light and new questions that people ask about it. But I think it can be useful to have a shared language to be able to describe what happened in the past. And on the basis of that, the Truth Commission can help bring at least an overarching vision of what the future of the country should look like. You know, in the absence of that, it can be very difficult. I mean, for example, in Northern Ireland, where I live and work, we have no agreement whether what we euphemistically call the Troubles was in fact a conflict. You know, some people say it's terrorism, you know, different things. So even the terminology we use to describe our past is not agreed. We have no agreement on who can be considered a victim and who cannot. And that complicates a vast array of issues in terms of dealing with our past, and also causes problems with our political present in terms of how we understand ourselves and interact as communities. So I think truth commissions, if they do that at a high level of abstraction, it can be useful, but within that, there has to be a recognition, I think, that any agreed narrative is a social construct. And it's always going to be partial and limited. So I think it's interesting, the questioner asked about the Holodomor, sorry, apologies. Yeah, there's often a debate where a truth commission is set up to go, how far back do we go? Because the present always has historical antecedents. You know, what gave rise to the current debates always go back further. And so that's often a question, is what is the truth commission tasked with looking at? Where does it place the temporal boundaries? But also, it's always going to prioritize certain narratives and accounts of the past. And there'll be voices who aren't heard. You know, truth commissions historically weren't good at telling women's stories of a conflict, for example. That has changed over the years. But there, you know, in each site, there are things that are silenced by a truth commission narrative, as well as being remembered. And so I think a truth commission plays a role in doing that, one that can be important, but it's only partial. And then the last point I just want to make is that in terms of societal acceptance of a truth commission narrative, for that to work, I think it's important that the truth commission is seen to be inclusive. If a truth commission only takes a testimony of one side of a conflict, or only appears to be interested in the experiences of one side of the conflict, then that will lead the other side to disregard it, to view it as illegitimate, to view it as something that's against them. Also, I think what's been striking in some societies where there's been perpetrator testimony as part of a truth commission hearing, which is not a universal experience of truth commissions, is that often what's most influential in changing communal attitudes, it's not hearing stories from victims from the other side, it's hearing stories of perpetrators from their own side, because that forces communities to reflect on what was done in their name. And that often helps build empathy in different ways. And so I think there's, you know, making sure societal acceptance happens depends on how the commission functions, how it operates, how it engages with different people, and what types of testimonies result from that.
Great, thank you very much, Louise. On that, Alexandra, did you want to add something?
Yes,
yeah.
I will add 2 comments. First, I strongly agree with the previous speakers that it's very important to find a right composition of this commission, with including the victims of both sides. And also it's important to understand that they will provide different point of views. And we always faced with that during the work of our mobilist groups. For example, when we know for sure where the shelling was and who used the force, but when you ask locals, they can have different point of view without any rational arguments, but they really believe in what they say. But I think that it's very important to provide such kind of platform because the communication memory live only for 3 generations, and then we have the cultural memory. And for us, it's very important because we are also, this war have a very huge informational dimension, and we struggling with different kinds of propaganda. It's very important to provide the floor to people and to save their testimonies and in order to have a tool to influence to cultural memory of Ukrainian people when 3 generations who remember these events will pass. And second, my remarks, it's not connected with question, but I think that it's very important when we speak about a composition of this Truth Commission, not to repeat the mistakes of Truth Commission in other part of the world, because if they will have only recommendatory character with no real instrument how we can use their decision, their conclusion, and their recommendation into force, I'm afraid that with current Ukrainian reality, we will have no result in which victims are achieved when they came to speak publicly about their experience.
Thank you very much for your comments. I would particularly agree on the issue of inclusivity, because so far, at least in my research, I have seen that those people supporting any truth-finding, fact-finding initiative for Ukraine, they would want to hear from the victims only, even though the victims from all the sides, but they would still hear the victims. And I think the point about hearing the perpetrators of one's own side that Louise mentioned is very, very important. And also, I think the gender issue is very important, because currently sexual and gender-based violence is under-prosecuted in Eastern Ukraine. As Alexandra has mentioned, there are so many concerns from the victims, from females who wouldn't want to report, but also from men who are ashamed to report the sexualized aspect of the torture that they have experienced. So looking for the ways to encourage the storytelling of this particular crime in the ordinary criminal proceedings or through a truth-telling initiative is very important for understanding holistically what means have been employed in the armed conflict in Ukraine. We have two more questions. The first one is from Mr. Richard Wright. So the question is as follows. Between 1943 and 48, a UN War Crimes Commission was created by allies, including the USSR, to bring war criminals to justice. It peer-reviewed the evidence of war crimes and encouraged national authorities to prosecute. Could there be a case for creating an analogous body to look into the crimes committed by Russian militias in the areas of frozen conflicts in and around Europe, Ukraine, Ossetia, so on and so forth? Who would like to take the question?
Sure.
Thank you, Myles.
One thing that I mentioned when I spoke was that in our minds, the post-World War II prosecutions tend to play a prominent role, but that was a situation of military occupation by the Allies after unconditional surrender. So both the IMT, International Military Tribunal itself, but also the trials in the particular zones are taking place in a context of full political authority. So that's just a reason of sort of political pragmatism that makes me skeptical, but there are, on the other hand, reasons to be more optimistic, one of which is that the last 5 to 6 years has seen a rebirth in universal jurisdiction prosecutions in Europe, particularly coming out of Syria, but not only Syria. And so many of the crimes that have been committed in the frozen conflicts will be crimes that come with universal jurisdiction. And many states have now started to take more seriously the possibility of prosecuting domestically, subject to political constraint and subject to evidence gathering issues and subject to actually getting people into the jurisdiction. So there's a sort of a pragmatic worry, but then potentially domestic avenues are a route that could respond.
Thank you, Myles.
Can I add one further possibility there? I should say I really enjoyed Alexandra's contextualizing of the violations which are happening in Ukraine within the broader framework of what's happening elsewhere in the region and elsewhere. When she was speaking, it made me think of Operation Condor in South America, where across that hemisphere, violations were committed by national governments, but often in cooperation with each other, and sometimes with state actors from one state traveling to another state to commit violations. So in recent years, where there's been a resurgence of accountability efforts within South America, part of what's been happening has been termed Operation Condor in reverse. And what that means is that national prosecuting authorities in each country have established bilateral or multilateral cooperation mechanisms. So where they're seeing the same individuals' names popping up in different contexts, they are helping each other construct cases and share evidence, or even different strategies in order to try and pursue accountability for them. And so that might be something that would be relevant to this context.
Thank you very much. And well, yesterday we heard at least about a similar initiative that it seems that the working group on transitional justice that is open to having a war crimes chamber within Ukraine. So I think there is a discussion about having a kind of hybrid mechanism within the country, which might be a good way to bring the best international experience and the knowledge of the local context, but obviously we'll see what initiative actually comes into being.
I'm sorry, may I add something? A very brief comment. Several years ago, together with my colleague from scientist circle and also from human rights defender circle, we tried to elaborate the concept for international hybrid tribunals for Ukraine. And we organized then with the assistance of International Renaissance Foundation, the huge international conference, to present this concept to Ukrainian authorities and to international community. But why we stopped and frozen all our efforts? Because we have no signal for political will from Ukrainian authorities, as well as no interest in international community, because such kind of mechanism, it's very costly mechanism. They need a lot of investment, a lot of money to be established. So I hope that if something changes, we can return to this idea.
Thank you very much, Alexandra. And we've got the next question from Julie Bureau. Hello, thank you for this very important topic. I think the experience of ICTY in relations with the local human rights organizations from Kosovo, Bosnia, Serbia, and Croatia would be very fruitful for Ukrainian civil society actors. What's your view on these processes? It would be interesting to include these experiences in the discussion as they're recent, and Yugoslavia is not that far from Ukraine. Thank you for your answers. So the relevance of the Yugoslav experience, could somebody comment on that?
I agree, absolutely, there's relevance there. One thing I would say is that we should really try to not treat the ICTY as we sometimes treat the International Military Tribunal as a great success. So clearly there are huge achievements, particularly doctrinally in criminal law. But as the question intimates, the relations with local human rights activists, civil society, needs to be unpicked specifically and individually. And what the effects have been domestically need to be taken almost empirically, case by case. So the complexity about those relations between the successful tribunal and local politics, it's a much more complicated story, and the answers will have to lie in the individual experiences.
Thank you very much, Myles.
I can add that I totally agree with the author of this question, because this experience are studied by Ukrainian human rights organization. For example, we have a close cooperation with a human rights organization from this region who are working on the issue of missing person. And we try to elaborate the appropriate mechanism in Ukraine, and the law which was approved several years ago in Ukraine, but unfortunately still not taken into force in practice, with a lot of elements are based on this experience.
I just had one point to this is in terms of the experience with the ICTY and the relations with local organizations, I think it's important to bear in mind that the ICTY was around for a long time. And during that period, it went through an evolution in its relations with local organizations. There was reflection at the start that it wasn't very good. It wasn't doing it very well. It wasn't reaching out enough. It didn't have enough engagement or awareness on the ground. And so they tried to change and engage much more. But also what happened was there was a hybrid tribunal set up in different parts of Yugoslavia to recognize some of the limitations of the ICTY. that it could only really ever prosecute a small number of those who are most responsible, that it was geographically and in other ways distant from the population on the ground. And so there was a sense that the establishing courts at the war crimes chamber in Bosnia could help bridge some of those gaps. And so thinking about what the lessons are from the ICTY, it could be about how the court worked itself or about what came next. What was felt necessary to evolve. And I think that points to the importance of some of the conversations happening in the Ukraine around creating some form of national process, whether it's internationalized or hybrid. But I think there's the experience of Yugoslavia suggests the utility of that.
Thank you very much, Louise. And we've got an interesting question from Mr. Jakub Hunter. Should an amnesty arrangement for Ukraine apply different standards to local and foreign fighters? And how should it distinguish between the two categories? By citizenship at the time of the crime was committed, by place of residence before the conflict, or by other criteria? And I don't know, perhaps it's more clear to the speakers, but I think it's unclear whether we speak here about the members of the regular army of another state, or we also speak about the mercenaries. So perhaps in your answers, you could address both variants. Thank you.
Sure, I'd be happy to take this one. There's no one way to write an amnesty law. Every country has widely different approaches. Sometimes even within one country, if there's a series of amnesty laws, they're drafted in different ways. And this is I think these questions that are raised here are things that the state would have national discretion around how to approach these questions. And I would see a lot of variation in terms of how these are addressed in the drafting of laws. So it's possible to draft an amnesty law that is limited by a competence affiliation. So to say this amnesty applies to members of the following, for example, and just keep it constrained in that way. I've seen amnesty laws which are limited by nationality. So they will say this amnesty is granted for Ukrainians, and so implicitly excludes others. Some amnesty laws contain provisions saying this does not apply to foreign fighters who operated here, and a small number have included residential requirements within it. So all of those variations are possible, and there are examples in place of how different ways they've been used. So if that was something that was being explored, I think there would be examples that could be looked to for inspiration. Although I think, as Myles was saying earlier, any approach has to be very much, I think, context specific always.
It's a very good question, but I would like to be asked by our politicians, because when previously our parliament voted for amnesty in the frame of Minsk agreement, and then sent this amnesty law for president, and president didn't decline this law and didn't sign it for years, nobody were interested of the opinion of human rights organization, of victims, of think tanks, of international experts. So I really need and think that it's very important to have in Ukrainian society expert and public discussion about such a very important issue of future of Ukraine. And this couldn't be limited only by several groups who take responsibility without any consultations for this issue.
Mm-hmm. Thank you very much, Alexandra. And there is a question actually from my colleague, another fellow from Chatham House, Mr. Mohammed Abdel Fattah. As a Palestinian who loses hope in a possible justice, and hearing today justice is possible for Crimea, is there a chance to make it possible, or is it just a wishful statement? How can we make sure that victims are not losing hope?
I'm sympathetic, I guess, to be Palestinian and feeling like hope is going to be difficult to sustain over such a long period. Here in Northern Ireland, we are 20 years into our peace process and 50 years since the conflict began. And our conflict was relatively low intensity compared to other places. And yet there are many victims whose cases have not been investigated yet, let alone had justice. So I think it's important to, firstly, to be clear with victims about the likelihood of justice. it'd be dishonest, I think, in many settings to raise their expectations that trials will be possible, at least in the short or medium term. So to try and manage those sort of communication strategies, I think is useful. But that's not to say that it is not possible. There are places where even where justice seemed impossible at the start of a transition, that many, many years later, the political context changed, the climate changed, legal obstacles were overcome, including amnesties, and then larger scale prosecutions took place. I'm thinking here primarily of Argentina, Chile. So that those examples suggest that it's possible. But to achieve that requires a sustained effort and requires institutional reform often to take place in order to create a climate in which the prosecutions are possible.
It's a very exact question. Why I say exact? Because it's express my own feelings. Because when you spoke with hundreds of victims and they have some expectation, you feel a huge responsibility for it. And there is no clear answer or clear algorithm what we have to do, but we elaborated a strategy and work from brick to brick. The first brick for us is to harmonize criminal code with international humanitarian and international criminal law. The second brick, which have already pushed from the desk corner, because last year in the frame of General Secretary from the General Prosecutor, we have a special division which investigate all international crimes. And this was a recommendation which human rights defenders promote for years. The next brick, which we now discussed, how to train Ukrainian prosecutors and Ukrainian judges to use properly the instrument of international humanitarian law. Unfortunately, I have no easy answer to this very complicated question. But also as a human being, I understand that I couldn't change much, but I totally believe that without my efforts and without efforts of my colleague, nothing will change.
I guess just thinking there that yesterday we heard a lot about Colombia, and a few years ago I was there for a conference with victims, and victims were asked to reflect on what justice meant to them. And I think what was really interesting for me was that it was a very rich concept. There were a lot of dimensions to what victims felt were the injustices they had experienced and what needed to happen for them to feel a sense of justice within the transition. And trials or not was only a small part of that. And for some of the victims, it wasn't even the most principal part. So for people who had been forcibly displaced, for example, it was the idea of getting home. That was what justice meant. It meant undoing the harm that they had experienced, enabling them to be restored. For people who had loved ones who'd been disappeared, justice was about recovering their remains. And so perhaps part of what could be done in terms of talking to victims about what is justice is thinking with them about what does justice look like for you as a multifaceted concept. And then even if some things can't be advanced instantly, if steps need to be taken before trials can happen, trying to push in other understandings of justice to try and deliver those sorts of outcomes for victims in the shorter term may help them maintain their sense of hope.
Please, does anyone of the speakers want to make some final remarks? Because we're nearing the conclusion. Well, then, thank you very much. I think the victims issue is a very good point to conclude the discussion. And I think it's especially an important point for the policymakers, because they really have to be honest in their planning and the expectations on how they communicate, how honestly they communicate these plans and the expectations to the victims. And I also would like to conclude with a quote from amazing Leonard Cohen, who sang that there's a crack in everything. This is how the light gets in. I really hope that Ukraine and all other conflict affected countries take these awful times as the effort to mobilize the civil society, as the effort for the better domestic policy making, and as an effort to hopefully qualitatively combine the justice and the reconciliation efforts. I really am thankful to all our panelists and to the people who asked the questions, who joined us today. I remind that this event was on record and it will be published soon, and we look forward to welcoming you at other events from Chatham House. Thank you very much for participating.